Welcome to the Wills and Estate Transmission Podcast, brought to you by Groots, specialist lawyers in wills and estates.
Hi, and welcome to the podcast channel for Groots, the wills and estates specialists. And we're joined again with John Groots, one of the partners of Groots itself. How are you, John?
Very well, thank you, Tony, and nice to be with you.
Thank you very much. So we're continuing on in our podcast sessions with you. You've been very generous, and we're covering off capacity issues. I know this is something we've covered before, but there's quite a few red flags that everyone needs to be aware of. So would you like to just start off giving us a bit of a general view of capacity issues?
Well, I think the first thing to mention is that to make a will, let's start with a will because that's the mainstream document here that we have. To make a will that's valid, one of the things that's important is that the will maker has what's called testamentary capacity. That is the ability to understand what he or she is doing, understand the resources that they're disposing of, understand those people who might be the fitting beneficiaries of their life work, that their mind hasn't been poisoned or distorted or whatever through any kind of disorder, that sort of thing. That's a general idea of the kind of capacity people need. Now, as our community ages, medical science is marvellous at keeping us going longer than we did in earlier generations. One of the things, though, that hasn't kept pace with that is an understanding of how the brain ages. And so we've got examples of Alzheimer's, dementia, what have you. So increasingly, as lawyers, we have to be very careful that if we are taking instructions for a will, that the person has capacity. Now, when I say that, at the end of the day, it's not for us as lawyers to judge whether a person has capacity or not. That's for the court, ultimately, if the issue is raised and disputed. But what we must have from any client is coherent instructions. So if we obtain coherent instructions, we have to make the will and also note in a detailed file note or file notes any red flags that came up. Oh, they didn't remember their son's name, but they did know that they had, $100 in the bank, or they had this or that. So I had a lady who was quite wealthy, and I asked her, could you just tell me a little bit about your resources? And she just said to me very matter-of-factly, well, I've got more than $100. And I wasn't quite sure whether she was meaning that as a joke or whether she was serious, but it turned out she was serious. And I said, well, when you say that, could you really indicate, do you only have $100 or do you think you have more? She said, oh, I don't know how much I've got, but I can tell you it'll be more than $100. So I recorded that. Her capacity was never called into question. What she did was very reasonable and appropriate. But so you can have little red flags, but I got coherent instructions. I made the will. I had a file note that expressed everything in relation to our conversation, but the issue of incapacity was never raised, nor should it have been, because I think she quite clearly knew what she wanted to do with her resources, even though she thought they may be a tad over $100.
Yeah, and some of these red flags are quite curious. There's one here, a client who may be elderly. I don't know whether that's a red flag on its own at all.
Well, I wouldn't have thought that's too much of a red flag. I suppose it just that you should be careful with any. Really, it doesn't matter whether they look old or not. But yes, it's probably a combination of things that just means that you have to be careful. And there might be just one single element. I mean, there's one judgment where the judge said you should be very careful if the person's over 70. Well, he was probably pretty close to 70 himself, because judges do generally are at 70, although in New South Wales they can go on for a few more years after that. So 70 doesn't seem very old to me anyway, but this judgment did say if you're acting for somebody and they're 70 plus, you've got to be super careful. Reality is you should be super careful always. But if you get coherent instructions in the context of a will, you make the will, and then you keep detailed file notes. But the other important document in the context of estate planning that is been the most contentious, or the more contentious of these two, I suppose is correct grammar, is enduring powers of attorney. Because to make an enduring power of attorney, you've got to obviously have the capacity to know what you're doing. And there have been many examples, sadly, where lawyers have been accused of not interrogating the client sufficiently to be satisfied that they had capacity. But say here in Queensland, we have to certify the person had capacity or appeared to have capacity, and you have to have very detailed file notes to make sure that you've asked all the right questions, the open questions, not the yes/no answers, that sort of thing. So it's a very tricky field. In fact, there are some lawyers who say, if there's the slightest red flag in the context of doing an enduring power of attorney, I just don't act. So there's a bit of disservice going on in a way, because they're making it so hard and so challenging really for lawyers. Where there is a red flag, what are you supposed to do? Well, yes, you've got to get medical advice sometimes and things like that, but how far you go and whether you've gone far enough, it's a tricky area now. And increasingly I think we're concerned about it.
Yeah, it's interesting you mention it, because there's one here that says a client having difficulty recalling things or evidence of bad memory and forgetfulness. Let's face it, right? Most people as they get older start forgetting things, and I think it's just an efficient way of your brain getting rid of old stuff. Does that necessarily mean that they have incapacity?
Yes. Well, again, I suppose it depends on what people forget. If they forget where they put their car keys, which was all, I think, occasionally, that's not a big deal. But if they forget that they've got 5 children and they think they've only got 4, well, you start to that's a real concern, that they've forgotten who their family is. It really is depends upon what seems to be forgotten, and how are we to know often, whether what we're being told is true or not. So it can be very tricky. I had an example of a client, and we had the most, I think, enjoyable conversation with each other. I was in my youth, Tony, and I'm sure our listeners will be riveted by this news, that I was a champion goat racer. And this man had actually raced a goat himself. So, of course, we bonded very quickly in our initial consultation, and we had a lovely chat. And then I turned and asked, then we had a little introductory chat, which I enjoyed, and we shared stories of our careers as goat racers. And then I said, now, how can I help you? And that's when it all went blank. He said, well, you'll need to ask my daughter. She brought me in. And I said, well, do you remember why she brought you in? He said, no, I've got no idea, but she'll tell. And so that was slightly more than a red flag. I had to just be naturally pleasant with the man and just say, well, that's fine. Look, we'll I'll talk to your daughter. And I then just went out and explained that he didn't really know why he was there and so on. And she said, oh, he's having a slightly bad day today. I'll bring him back when he's having a better day. But I didn't ever see him again. So I don't know what she expected that I might be able to do in the circumstances, but you do have to be very careful. I had another case where a man brought his wife in. She was apparently very wealthy, and he offered me quite a lot of money if I would make a will. And he said, she can sign her name. And he put a piece of paper in front of me and said, sign your name there, Joan. And Joan signed her name, but she just wasn't there. He said, I'll make it very worth your while. He said, to make a will, she needs to leave it all to me. And I said, okay, well, not today.
Yeah, exactly. And that's another red flag, whether the parties written the client's communications.
When she was going to have a better day, he was going to bring her back, but I didn't ever see her again either.
Yeah, exactly right. So that is directly in those communications. Exactly right. Another one that's interesting here. So maybe we need to crack open the calculators, whether there's ability to perform simple calculations. Have you ever been tempted to test someone doing that?
No, I've never done that. That's the mini mental test, where you start with 92 and take 7 off it or something like that. But yes, no, I've never done that. In fact, it's not I think that's going too far myself. But I just approach it on the basis of what the law says, and that is everybody is presumed to have capacity.
Yeah.
Starting point. And that's fair enough too. I think it's our human right to be regarded as having capacity as a starting point. And then after that, it's the case of listening or observing the red flags that you might have to record. And it'll be different for an enduring power of attorney and a will. If you get coherent instructions, you could have a dozen red flags, but you get coherent instructions, you make the will, but you must then do a detailed file note of the red flags and the discussion generally, or the interview generally. But with powers of attorney, it's enduring powers of attorney, that is, it is a much more serious game, and one where you don't proceed if you have doubts about the capacity. You cannot, doubts that you can't resolve. It's tricky as to when you have you resolved them satisfactorily or not, but it's more a professional judgment call. But by and large, I think the cases are urging the greatest caution in proceeding when there's a serious red flag.
Yeah, exactly. Okay, so just one other little thing here. You mentioned before about it's the court that decides on capacity. So that's correct, isn't it? It's the courts that decide on capacity, not the doctors.
That's right. And many, many cases have made that point. We've had doctors who've said, I don't think the person had capacity. I've looked at the medical records, etc. And the court has said the person who saw them on the day that this will was signed and took the instructions and has given advice that, yes, the person understood what they were doing and the rest of it, they preferred that evidence to the evidence of medicos. Many times the medicos haven't seen them. They're just relying on medical records and so on. At the end of the day, it's what the court, where the court finishes up as far as listening to the alternate views on capacity. But the solicitor who meets the client in person, in private, and satisfies themselves that there was capacity, or at least anyway, they got coherent instructions. They talk about the red flags if they're interrogated on that, of course, which they would be, and then the judge makes his or her mind up as to whether there's capacity or not.
Great. Thank you very much for your time.
Pleasure.
Thanks for listening today. Don't forget to subscribe, and if you require any further information, please go to our website www.degroots.com.au and book a consultation. The contents of this podcast do not constitute legal advice and are of a general nature only. Listeners should make their own inquiries about their specific circumstances and seek legal advice.